Professor Dr. G.S Bajpayee, Vice-Chancellor RJNUL Punjab. Sir is an academician, an eminent author, a researcher, and a well-known criminologist and social scientist. Sir holds his doctorate and postdoctorate from the prestigious Leicester University as a Commonwealth Fellow. Sir is a passionate criminal law teacher for past 20 years. Sir is a pioneer in the usage of the expression critical criminal law, which has been adopted as an LLM course in most universities of law in India. Sir has also contextualized the novel paradigm of victim justice, victim jurisprudence, and wrongful prosecution in the Indian context. Sir has held positions at IIPA, Indian Institute for Public Administration, Punjab Police Academy. Sir has previously served as registrar at NLU Delhi, where under Sir's tenureship, the university reached remarkable heights, not only in the field of research, but also ranked number 2 for consecutively 3 years. As far as research is concerned, Sir has been a researcher par excellence, where he made some exemplary research work under prominent and prestigious publications like Sage, Thomson Reuters, and Bloomsbury. Sir has been conferred multiple awards and honors for his exemplary and consistent high quality research work. Prominent among them has been J.B. Pant Award, Best Social Scientist Award, the prestigious Professor Kochalinga Award, and the ISC Reckless Komarapa Reckless Award, which is considered to be the highest honor of ISC. In terms of numbers, if one has to put it in numbers, Sir has authored more than 21 books and monographs, more than 50 pieces in terms of research papers in esteemed journals, and more than 50 OPEDs in the dailies like the Indian Express, the Hindu, the Tribune, and 13 project reports. Sir is known for his exemplary research work all over the world. Sir has undertaken prestigious international assignments. Sir has been to the University of Paris, France, where he significantly contributed to the French criminal justice system. Sir has been the notable speaker at University of Hong Kong, Netherlands, Germany, and many others. Sir has also been a collaborator of research project at University of Oxford. Sir has been the principal co-investigator for MHRD UGC e-Pathshala project, which has led to the creation of various e-content and video lectures for different law courses. Sir has been on the advisory board of BCI, where he has led to the creation of development in legal programs and education. Sir has also been the lead in the creation of MOOC program. Sir, in terms of research, has been very few who has been stressing on the need for empirical legal research and the need to find the right balance between theory and practice. Today, Sir is going to enlighten us on the topic quantitative, qualitative, and mixed methods approach, which seems to be the problematic area for most of the researchers. So thank you, sir, for sparing your time and giving us an insight into the problematic area, which seems to be the main concern for most of the researchers. So over to you, sir. Thank you.
So you have to unmute yourself.
Yes, good morning all, and thank you so much for having me today here. My greetings to Professor Tavraj, who persuaded me to this wonderful meeting today. And as a teacher, I am someone who would always like to interact with the students, faculty, researchers, and especially on this kind of subject where you are discussing innovations in teaching methods as well as research methods. I congratulate the GDGU University for launching this very intensive program. I could see the content of this program, and I really compliment that The leadership is paying so much attention to some of these areas which are key concerns of law academicians in the country. Friends has rightly pointed out that legal research is something which is these days being focused. I'm happy that we started this movement of emphasizing legal research through National Law University Delhi, and thereafter I have found that lots of universities are now probably have understood the importance of this particular area, and they are now. However, the skill development, capacity development, especially amongst teacher with regard to the conduct of empirical as well as doctrinal or qualitative legal research, is something which has yet to actually take off, and therefore such programs become hugely important. Coming to the topic, let me pick up the topic quickly so that we can utilize. I propose to do some, the scheme is that since you have put up both the topics together, however, in an ideal scheme, these two things need to be separated, because this is not a classroom lecture where I need to tell you the difference of empirical or qualitative or quantitative. So in this time, only one of the kinds or one of the types can be emphasized in this meeting. So I would begin with a general remark on the kind of legal research that we do in terms of qualitative and quantitative, and then probably I'll come to qualitative rather than quantitative, because I feel still the law academician, though I am personally speaking, I'm more comfortable in empirical legal research quantitative method. However, for this session probably I'll be emphasizing qualitative doctrinal more and more, so that majority of the researchers, as I find, are trying to engage in a doctrinal and qualitative method. So just to start sort of a comparative understanding of both the kind, I will make some initial remarks, because these remarks are very important to lay a platform. So my one assumption is that legal research as such is not the part of our thinking process or our thought process. We think that this is something very vaguely we understand. But I think method is very important. Probably we need to bring in very strongly the importance of method in our understanding of the subject of law. So that method consciousness is very, very important. Temperamentally speaking, or speaking through the basic idea of legal content, we are a very content driven people. We try to consume more and more written content without really being bothered about the methods of construction of that text. The day you start focusing on the method of the construction of the content, then our understanding and awareness will change. That is the first thing we need to. So tomorrow, suppose you read some article or a book, read that book or article for the purpose of knowing the underlying methodology. There is a difference. I am making a very subtle remark which needs to be imbibed. I am saying, first assumption, most teacher, most researcher do study to consume the content. So content part, we are very strong. And law teachers are very strong in content terms. You can tell me number of sections, you can tell me the case law, you can tell me the good writings and all those. But method side we are lacking. So probably next time you read a good article, read the content of course, but also try to look at the construction side of that article. So the moment you become construction conscious or method conscious, your level of understanding will change. So I think if you are in classroom or if you are teaching some student, that's what I always say. In law academics, we have yet to go to the why of the law. We are teaching what of the law. So just we are telling the student that this is the law, but why this law is like that. So in order to address the why of the law, you need to be a researcher, and to be able to be a researcher, you need to be a thinker. And thinker is something which is very important. And law jurists, law academicians are not really assuming the role of jurists and thinker. That is the first problem that I see. We are teaching more like an advocate, where we are trying to teach the student how to apply the set of laws to the facts. But that is okay. That is one part. But law schools have a bigger role to play. They need to train the student to the what I call a critical thinking. No, critical thinking is a methodology, and this should be imbibed, and this should go hand in hand. So, what is the critical thinking? So, if you are into a doctrinal method or a doctrinal understanding of the subject, so we are a very conformist kind of people. Conformist means we are agreeing to the content most possibly. As far as possible, we agree with the content. Sometimes it is in the respect of the fact that some senior person has written. Sometimes it is because it is written in the book, which are very classical. You never imbibe or you never teach. To imbibe or to develop an alternative opinion, alternative paradigm and alternative thinking. Now this alternative thinking is reaching very fast to the Western legal academics. If you see, they are always inclined to explore the alternative paradigms, because classical paradigms are fixed in law. So suppose I am teaching jurisprudence, criminal law, and environmental law. Classical paradigms are fixed. So our teaching most of the time is focusing, endorsing, and conforming with classical paradigms. And there is a comfort level in teaching the classical paradigms, because you are not challenging anybody, nor you are being challenged by anybody. So there is a happy situation, because you are a conformist. You are agreeing largely with what is being written, produced, circulated, delivered. However, I am talking about ability to identify alternative paradigm, what is called paradigm shift. Are you able to bring in those shifts of paradigms in your respective area of teaching? Is there any scheme available? What is the source of this alternative paradigm? I'll come to this. Is the basically I'm talking about qualitative doctrinal legal research. Ability to identify the available alternative paradigms in the field of legal academics is the first requirement that a teacher ought to have. Now, I can give you certain example how the alternative paradigms have changed the complexion of legal research, India and globally. So like these days, we very often we listen feminist studies, feminist perspective of criminal law, or feminist reading of conventional laws. What is this feminist? Now, the origin of feministic explanation of law emerged as an alternative paradigm, because we had a very patriarchal understanding of so many legal issues. But when we adopted that feministic understanding, we were able to receive a different kind of perspective, now human rights perspective, because we have been trained to understand law from the lenses of the state for a long time, because laws are the creation of the state. But we have lately realized that if we try to understand these laws from the perspective of the people, human rights dimension has brought that change in understanding very powerfully. And you see now a different kind of content and legal writings emerged. And there are now critical legal studies movement, CLS, in late 80s, 90s in the US. They have started changing. So actually in the US, this movement started like the classical legal thinkers and the realist jurisprudence in the US has, infused what is called the contextual understanding of law. Because law in rhetoric of the law was the classical understanding of the law. And reality of the law, what realists were saying, that you cannot detach law from reality. So context of law became very important. Now, if you are teaching any black letter law, if you take the law to the context, if you take the law to the people, your own understanding will change. So there are two types of researches. One is called, which is very pure research, legal research. Doctrinal research is research in law. Doctrinal means you are examining a doctrinal development of a concept in constitution, environment, criminal law, take any. So if a doctrinal research is research in law, whereas empirical research is essentially research about the law. Research in law and research about the law. This makes the whole difference. Research about law means you are ready to appreciate those factors which are non-legal, though they essentially have some impact. Ability to underscore the impact of external factor on the adjudication in the courtroom and wherever. So there are a lot of, so if you are supposed studying the profile of lawyers, logistics in courtrooms, do these things have some impact on the efficiency of the court? This is the question. I don't know how many of you read, I have done an article couple of 2 days ago. Judicial behavior. I have said, have you seen, anybody has seen that article? I'll just share that article. So it has been published in Tribune. I have studied that there is a psychology of judging. And I have said that the matters regarding the judgment, so judgments are not always decided as per the law. They are also decided as per the various factors outside of the law, which are influencing the judge. So judges' behavior is influenced by a variety of external factors other than the legal factor. It looks as if judge is deciding strictly as per the law. But judge as a human being is also influenced by his own ideology, his own background understanding, his own experiences in the profession, his own predisposition to certain things, his own past history. Though he would try to eliminate these factors as far as possible, but I'm saying these factors operate at a subconscious level. So judge is not in a position to really explore or really recognize the impact. Richard Posner has written a wonderful book, How Judges Think. How Judges Think, Richard Posner is saying essentially the importance of external factors. So suppose as a researcher, you are trying to study what are the external consideration in the grant of bail in a district court by a judge. This would be an empirical study because it is research about the law, how law operates, what are the factors impacting the adjudication in the court. And a study, this can be a quantitative study in terms of testing a hypothesis whether these factors have some kind of influence on the judging. But if you are actually analyzing a law, say UAPA law, in order to understand the procedural intricacies resulting into the denial of bail, this is a doctrinal qualitative study because you are examining the pitfalls or flaws, procedural intricacies within the law to understand a particular outcome. So I'm saying that depending on the subject matter that you have before you, you have choices to adopt different research methodologies or research designs. So suppose if you have a pure qualitative stuff which you wish to, because certain things cannot be possibly done empirically. They are best suited to be explored by a qualitative or doctrinal design. I for instance, I'll show you a small PPT to provide you a basic understanding as to what is the idea of qualitative research, or what is the idea of this difference between the qualitative and quantitative research. And in that context, probably you can appreciate that it happens like this. There is a window. I hope the window is before you. Can you confirm me?
Yes, sir, it is visible.
Yes.
So this is basically the difference between the qualitative and quantitative research. Qualitative research, we are looking at the phenomenology, means how the people feel. You are studying the people in their natural environment, in their life cycle. And qualitative research is more holistic, more so wholeness. So studying people in their environment. So if I want to study lawyering in the courtroom through an observation method, and this would be a qualitative research. However, in quantitative research, basically, we are adopting a deductive technique where we are probably using the inference drawing through a very controlled, research design. And as I said, in qualitative, however, the data that we are collecting, they are from the real world situation. So can you imagine an example where suppose a legal researcher is interested to understanding how cross-examination happens in a trial court, and he has decided to collect the data from the trial process in a district court through an observation method. So he is essentially interacting with real world situations, and these data would be descriptive, because unlike the quantitative design where probably you can collect more systematic data, he is making notes. So he is essentially noting descriptively, emphasizing the holistic. Holistic means we are looking at the entire process. Like in quantitative, we are only concerned with a particular aspect of the information. Here, if you are listening the judge, if you are listening the lawyer for the purpose of collecting the data regarding the art of cross-examination, then essentially you are looking at the process and outcomes. And this data is inductive. What is inductive? So inductive is essentially we are looking at one unit of observation, one situation, and we would be trying to generalize this observation, presuming that the cross-examination happens like this. This process is called inductive. And we would also probably describe the meaning of research findings from the perspective of the research participants. I think you need this sentence twice, because if you understand this, then you understand the qualitative or doctrinal research. Idea is meaning of research findings from the so meaning to the researcher, meaning to other stakeholders, and meaning to the participants are very different. So suppose if you ask how law operates for police officer, for judges, they have a different meaning. But if you ask the people who are at the receiving end in the law, they have different meaning. So essentially the doctrinal research is about collecting these meanings for the participants. I would stop here. Do you get this whole idea that what I'm trying to say? Meaning of that particular research finding are that data to the people. I think this particular point we are missing very, very regularly. And I think once you go on this side, then probably you will understand a lot of things. Now, if you see what are the other dimension? Other dimension of qualitative research is where we can also see that data which is collected in this format is always used in a descriptive form. What is the descriptive form of the data? Descriptive form of the data is where we see The data being recorded qualitatively. Now, what are the prime methods in doctrinal research? 3 methods. Screen is still visible?
Yes, sir.
Yes, sir.
So please, you can see on your screen. These are few methods. These are not the all methods. I'm adding here a couple of methods which you can note down. In qualitative methods, basically, we are interpreting a reality or a situation in qualitative terms. So participant observation, in-depth interview, focus group discussion, content analysis could be some of the ways to collect the data. And this is a conversation, basically. Sometimes your data collection is through conversation. Many people would wonder whether can there be a sampling in qualitative research. In qualitative research, essentially, the nature of sampling is purposive. Can anybody give me the example of purposive sampling in a doctrinal research? Let us also have some conversation instead of, is there any example? Can anybody give me the example of purposive sample?
Good morning, sir.
Yes.
My name is Dr. Purvi. I'm not very sure if I'm right, but I guess when we choose the kind of thinkers or philosophers related to the topic that we are trying to justify, when we choose those thinkers based on our opinion as to probably this is the kind of theory that will fit into what I'm trying to say. So choosing or relying on on our own judgment wherein we pick up those people that we are trying to articulate here is, I guess,
Great. You are right. Can anybody give me example also? Maybe.
so for example, in my PhD thesis, I was trying to say that we have moved from a place of theory of non-appropriation to appropriation, wherein we are trying to make use of the celestial objects in space and we are trying to bring them back to Earth for our benefit. So I use the John Lockean theory of labor. Whosoever could get it is trying to get it back. So whoever is able to access that labor is bearing the fruits of labor. So
Okay.
I could have used many other people, but then I used Locke because he clearly talks about using, the labor with regards to immovable or movable property. So that was what I said.
I'll simplify this discussion by providing you some example. So suppose I'm doing a qualitative study to understand the problems of some member of LGBT community. So after Nautage, if I'm interested to study the impact of Nautage on these people. All right. So I contacted one person from LGBT community, and I'll contact the people of the similar experiences, those who are LGBT. This is a purposive sample. Purposive, there are 2 types of sample: probability sample and non-probability sample. Probability sample follows a certain scheme and method where the number or the choice of a respondent would come randomly. And purposely is a word opposite to random. If you are not doing a purposive sampling, means you are doing a random sampling. But if you are doing a purposive sample, you are not doing a random. Random means beyond your control. Purposive means controlled. So suppose I have to choose a person of some characteristics like LGBT. So instead of going random, I am choosing 10 members, 20 members. That is purposive. Like snowballing sample. The person with the same experience to be contacted. So I have contacted one LGBT. I'm asking, do you know any other person with similar? He or she would tell me, and I will go and contact him or her. That is snowball. So let us understand how this sampling function. These are some of the ways. Advantage and disadvantage, I am not going really. I am just telling you through a very simple, methodology. That is, I'll be showing another. Meanwhile, if you have any question or query at any point, you can easily ask. That would make this discussion more and more, interesting. I'll show you a small, slide to give you more insights into the entire idea of this thing, qualitative research. And I can tell you that qualitative research is more difficult to do rather than quantitative. That's why majority of the people in law do not have enough clues as to what is the doctrinal or qualitative research. And qualitative research, as I said, is conducted for the purpose of construction of theories or hypotheses. So you have a theoretical idea which you want to testify, or if you want to evolve a theoretical framework to interpret or explain a particular phenomena. And for that, you do a pilot study, a deep analysis, or a case study, or a process study. I have given the example of process. So suppose you want to study the dispute settlement process in a tribal community. That is a process analysis. You need to do the continued observation, and probably you will be able to classify certain things, and you can theorize certain things. So this model is essentially the model for a good doctrinal thesis. Again, if you see, what are the basic ideas in qualitative thinking? So as I have said, you need to understand the qualitative thinking against the quantitative understanding, because in quantitative we are more sort of controlled, and the objects are pre-decided and so many things. But here the strong focus is on a single case study. So single case study of a village can be a good example of a qualitative study. In that village, you want to understand certain process of, or you want to do the legal issues relating to land in a village, or anything like that. Openness. So there is an openness. As I said, the people are contacted and studied in a natural environment, and their ideas and experiences are collected. So there is a little control in that sense. However, this is a more flexible research design. Second is subject first. This is very important. I have been saying wholeness, history, problem orientation, and natural and daily environment. So suppose if you want to study a life of a prisoner in a jail, the best way to look at them in the prison and spend a day with them to understand how they behave in a natural environment. So wholeness means how the day is spent. And the result would be understood as a process of generalization. You can do this induction. So having observed something, what you are going to induct? Is there anything which you can theoretically formulate and try to generalize, and the extent to which you can frame the rules, or you can quantitatively also say certain things. But the fact remains that there is an interaction of researcher and object in this situation. And therefore, this whole exercise developed in a very, very linear way. Now, generally people think that a linear model is only possible in a quantitative methodology. But here you can see, you can start with a general theorization. So you have, you think that the dispute settlement in a village happens a particular way. Then you have a hypothesis. And that hypothesis you can operationalize. I mean, what exactly you are going to see. You can decide your sample, you can collect the data, you can interpret the data, and you can do the validation. I would request you, all of you, because so in so many places, when I interact with the law researcher, they are clueless. Generally, they will say that I have done a doctrinal study. But if you ask how you have done that doctrinal study, they don't have. But if you are able to answer your question, or explain your thesis in this model, the first model, the linear model, So linear model for a qualitative or doctrinal research is something which you can easily identify and implement. This should go as a very important takeaway of this discussion today. And if you have anything to ask on this, you can switch on your microphone and ask. Anybody has any question up to this stage? Okay. Now, there is a circular model also. So essentially, the qualitative research will not always move in a linear. Ideally, we plan every research in a linear fashion, but you will find an account of the nature of subject which are there. You will find there is a circular model. Now, this circular model, you please look at very carefully. This is the actual way where we can see the research happening, especially the doctrinal or qualitative. You start with a preliminary assumption. And what is the preliminary assumption? You can give an example. So if I think that the prisoners are not provided enough legal guidance to secure plea bargaining in a jail, I suppose I have this preliminary assumption. I can go to look at those cases which can probably substantiate my preliminary assumption, and I'll try to interpret it. So suppose 10 cases I study or 5 cases I study in a prison to understand the availability of legal guidance for them to prepare their plea bargaining applications. Now I would again try to compare with other group of prisoners, whether it is happening in other groups also. Again, you are collecting certain sample, and you are collecting, there are multiple samples now. So you want to understand whether in all categories of prisoners the same thing is happening, or does it change with the nature of offenses they have committed and all that. And what is finally you theorize? Are you able to theorize? The prisoners of all categories generally do not have enough legal guidance to seek plea bargaining. Or you can say that the petty offenders are more likely to get legal guidance in filing their plea bargaining application. This is very important. Did you follow? Anybody can give me a quick feedback on this with a different example. Rajiv Gandhi? Will you be able to apply these two models in a real situation? Anybody? Yes. Anybody has any question? Okay. Now, so I think if you continue to, whenever qualitative research figures, if you adopt these two models, probably you will get enough picture of what you are probably trying to look at. Now, integration of qualitative and quantitative. Please remember that there cannot be a purely qualitative or purely quantitative research. Sometimes these two methods become integrated to each other for the purpose of achieving more comprehension for your research. So in both the research design, we'll prepare this way. There would be a collection of data, and both kind of data would be collected. However, in qualitative, it is more of exploration. In quantitative, it can be interview method, it could be questionnaire, and you will be collecting the data. In quantitative, basically, it is a survey type of methodology. In qualitative, it could be one-to-one, face-to-face, limited method. And quantitative, you can have experiment and other things. So this model is for a integrated approach. Now, finally, what kind of research topics, problems, and the question which can be involved? Now, this is fantastic, diagram that I'm trying to show you, and you can probably realize that what I'm trying to speak. So first you look at There can be a single case analysis. Single case analysis. Single case analysis means you are only examining one aspect. It could be a document analysis. Document analysis, generally in law especially, you have this document to be studied and therefore you are using it or you are trying to analyze the document. And the method that would be probably used in document analysis is called content analysis. Action research means you are into the field to have something. So action research is different, and field research. Qualitative experiment are also. So two different sample and you are experimenting them, whether with a change in one situation is resulting into any change in other situation or in other person, and you are doing a qualitative evaluation. Process of qualitative research would simply involve three stages. You are collecting the data, you are preparing the process, you are analyzing the process. And after doing this, you are looking at, if you want to start this research, you have to look at the literature and experiences of the people. And through these sources, you will get enough ideas for your research. But I think the overall process would be where you would be formulating the overall question, specific questions, what are the concepts, and how you are selecting appropriate designs and methods. And the further steps are shown on this slide. Many people still believe that the qualitative research do not follow a fixed framework. Here I am actually presenting you a proper framework for a doctoral research, which you can utilize in organizing your research if you are into any doctrinal or any qualitative research. So these are some of the ideas which you can probably look at and probably utilize. But I would still say that the common methods or common research design remains these six. So if you are into any, now it would depend what kind of subject you have. So suppose you are only analyzing the cases, then you are more into the document analysis. But if you are doing some field work or single case analysis, so these would be some of the ways to look at the qualitative legal research. But but in all cases, when you collect the data, these three things will involve group discussion, interview, and observation. So a good legal researcher is one who develops some competence and command over these methods to be able to generate the data for these research. And if you see, the interview process, especially in qualitative research, would follow a very different methodology, because purpose of qualitative research and interview is to understand the lived realities of the people. So suppose I am doing, say, very famous Bhopal gas tragedy. So stakeholders can provide you some experiences with regard to that issue. And that would be basically helping you to collect a lot of data. As I said, there is a grounded theory. Grounded theory is essentially means you are looking at the experiences of the people in their world. Now, this sentence, I cannot explain beyond it. You're collecting the experiences of the people about their world. Not essentially you are collecting the data according to researcher's choice. We are actually trying to induct and collect the data. So grounded theory is essentially the key premise in the key philosophy involved in the qualitative method. And content analysis is something which we are deducing. So content so suppose I'm doing a content analysis of a document or a writing. So in that sense, that would be very, very useful. There are different ways to do this. However, I would revert to you at this stage to know if this helps or if this has really given you any understanding. Any question up to this stage? I have shown you a lot of things. Unless you raise any question, this will not, research method cannot be taught through a lecture. That is the whole problem. Anything? Yes. Yes.
So we have a question from Nusrat Khan. Yes, please unmute yourself.
So, sir, can these methods of grounded theory and the content analysis be used together for a single research work?
Yes, yes. Of course. Of course. Because see, grounded theory, you are essentially, collecting the data about the people. So suppose your research, you have to take an example. As I'm saying, you are studying the dispute settlement in a village or in a tribal district. So you are looking at the process itself, and you are deriving the meaning, how people are actually, dealing with a situation. That data you need to be collected. Content analysis is basically, if there is any writing or any document or anything, you are exploring certain ideas. I don't know, I have done a study some time back that was published in Chile. We have studied the gender notions in the judgments delivered by the Supreme Court. Hypothesis was that at times the judges do indulge in what is called victim blaming, or they utilize or use certain gender insensitive remarks. So how it happens, why it happens, in what kind of cases it happens, there can be multiple issues involved in this. So we have decided to do a content analysis of 50 Supreme Court judgments. You can look at this paper to understand the method, as I am saying, not understand the content. And in that paper, we have mapped those remarks which were gender insensitive or which were within the frame of victim blaming. And we have mapped the frequency of these remarks in as many as 50 cases. We have tabulated the frequency with which they were occurring. We have tried to know when they happen in terms of the profile of the victim, profile of the offender, type of the cases, and we have cross-tabulated this information along with various other variables to produce a context of gender insensitive remarks being indulged in by the court in a variety of situations. I'm saying that every document is full of information other than what is visible. Ability to identify the hidden information, to be mapped and plotted, and to be used for the purpose of a doctrinal research is something very important. I'll give you some more examples. I don't know how many of you are aware that Justice Hub has recently started compiling the data of various researches being conducted in this country in the field of law. They have different data set. Now, India Justice Report is coming up. Can you utilize a published data set? So suppose India Justice Report has published the data about the ranking of police in a state, right? I want to study whether the performance of police, suppose my hypothesis is, suppose the performance, so India Justice Report has only published the data on the performance of police index. I have developed a hypothesis. The performance of police is linked with the development level of a state. Developed state will have better policing, and underdeveloped, and vice versa. To check this hypothesis, I have to utilize the India Justice data, rank data, I will also collect the development profile of various states. I will then cross-tabulate it, and I would be creating a new set of information which was not originally there in any of the report. And I'm saying policing, the success of police is more and more in developed state rather than under, or whatever. I am trying to give you a very important clue that you have different data sets available these days. However, you can probably utilize these data sets and try to map the information which is available in other domain. You can contextualize the different kind of information available and probably do your legal research in a very fresh way. Any other question?
Sir, I would like to make an observation regarding these two methodologies. So, like I come from a non-law background from social sciences, and where I've seen like on a very repeated basis, we basically the combination of both these, if we term it as content analysis and ethnographic study or participant observation, it works best. Like for example, if we take the case of tribal communities, ethnographic study would give us a glimpse of their world, their realities, that would help us make observation. At the same time, content analysis, when we go and spend time with tribal communities or any other ethnic or sensitive group, we basically not only live their life but also look at the content which they consume on an everyday basis. Like for example, the kind of calendars they have, or maybe some other kind of laws and rules and regulations which they follow in their own community. So I think it works both ways. And as you pointed out in the beginning of how there is a need in legal research where we need to not only be conformist to the state's idea of what is right, but also to look at what is it that is not right with the state documents. So I think content analysis and grounded theory works best in terms of shifting from the questions like what is to why and how it is and what could be done to bring in policy changes. So
Yes. Yes, you are right, because in all legal or even in social sciences, the contextual understanding of a phenomena is more important than studying these phenomena in solo. Law, essentially, with law, the biggest problem with the law has been all through in this country that there have been very narrow studies without the context, and therefore we couldn't generate enough understanding, contextual understanding of those processes which do impact the adjudication and other kinds of dispositions. And therefore, I think the traditions of legal research have been very, very limited because we have not ventured enough, I would say. And we have not allowed much experimentation in these fields, like fusion of social science with law, interdisciplinary research. We have cemented the wall very rigidly to limit the knowledge, and therefore we have suffered a lot. But I think now the time is changing where a lot of literature is emerging. And this kind of research nobody looks at these days. If you look at the Western tradition, nobody, the kind of research we are doing, that what is the right to life or what is the this and that constitution, nobody would look at unless you bring some fresh light, or if you bring in the impact of, like I have just mentioned, so many constitutional bench judgments like Nautej, Puttu Swami, they happened. But nobody knows the impact of these judgments. Because to study the impact, you need to do empirical study. And to do the empirical study, you need to have capacities. And to have the capacities, you need to imbibe the basic understanding of RM. So this is a circular process. And therefore, it is important. Any other question? I have to leave at 10:30 because I have some other engagement. I'm here for another 5 minutes. So if you have,
Sir, indeed, there was my mic. I realized later it was off. Indeed, I was about to ask very small, important area. Uh, as we are continuously talking and speaking, through many writing in the context of that post-retirement independence of judiciary, in the context of independence of judiciary, post-retirement, whatever post, government post, judges they are getting, so that is just because of some or the other way in pre-retirement stage, they may be favoring to the government wherever governments are the litigants. So here I just thought, and I again refresh my memory when you talked about document analysis in the context of doctrinal approach or qualitative approach. So can we have like 100 judgments of those only judges who got post-retirement appointment in the government, and understanding those judgments only where government is the party, understanding those documents only, so that this particular hypothesis which we are continuously framing, that post-retirement judges, wherever and whenever they are getting the government post, pre-retirement stage, they are some or the other way favoring to the government. So this study, can it be based on those document analysis? Just I want to take your suggestions on this aspect.
yes, this is possible. And you can definitely study the nature of judgment in past several years in terms of favorable judgment and non-favorable. You study a very good work, probably just in order to give you some idea of research method. You study a book by Scaling Justice by Shalashri Shankar, a very prominent work. She essentially did a study about the Supreme Court judgments before emergency and after emergency. Hypothesis was judges have become suddenly more sensitive to human rights issues after the emergency. If you see, all human rights jurisprudence in India emerged after the emergency period, because there was a different understanding about the same law and same regulations. So you can definitely look at this is a jury matrix basically, where you can collect and the data and favorable data, and look at the nature of judgment given, and of course the kind of assignments the judge have assumed. Though we need to be very careful in deriving our inferences. Sometimes we create inferences because they suit to us. Objectivity in legal research is very important. The job of religion of a researcher is objectivity. Religion of a researcher is the objectivity. And unfortunately, objectivity is becoming a big tragedy these days, big casualty these days, because we are compromising the objectivity, giving preference to so many other things. Your ideology may be one thing. You are so fascinated to your ideology that the truth gets blinded. The religion of, as I am saying, not duty, I am saying the religion of researcher is to demonstrate the objective reality as it obtains. You are nobody to interfere with the objective reality. We need researchers. That is why I'm saying researcher is a very, you have to be you have to qualify this word to be able to call yourself as a researcher. Because then you are not trying to, endorse your own ideology. That's why there is a crisis of legal research. You need to be bold enough. You have to say certain things. But again, you have, so in research generally it is the method which is defended. If you are methodologically correct, your findings will have a good credence. But if you do not have any methodology, your findings would be questioned. That is the whole thing. So research method is applied to maximize the objectivity. Maximization of objectivity is the function of research methodology. Otherwise, these things you can say even without research. Even without research, many people are wise enough to conclude anything. But then it will not be good enough. So these were some of my ideas which I have shared with you, and I hope it was useful. And today I am a little constrained by time to join something else. But it was all my pleasure, and really I thank you everyone here to have given me a patient hearing, and it was a nice discussion as well. So thank you, Professor Tabrez, and everybody in your faculty and all the teachers. We can reconnect sometime to have more such interactions in future. Thank
Thank you,
you.
sir, for a nice interaction and very important aspect we have discussed. We'll be happy to have you in the campus once the pandemic gets over. Yeah.
Thank
Thank
you.
you, sir.
Thank, thank you, sir, for the informative session and bringing in insights on the innovation that one could bring in legal research and teaching. Thank you, sir. Thank you, everyone. Thank you, Professor.
Thank you, sir. Thank you.
Thank you, sir.
Thank you, sir.
Uh, the the feedback form is in the chat box for the participants. Please fill in the form. It would be available for next 15 minutes. Thank you, everyone.
Dear participants, the feedback form link is available in the chat box. Kindly fill it. And we have our next session at 12 p.m. The topic of that session is outcome-based teaching and learning method. The resource person for that session is Professor R.K. Chopra. See you all at 12 p.m. Thank you.